So maybe I'm going to wait till 11:33. She had initially said 11:32, but
Yes, that'll be fine, Brenda. Ryan, if you can give us an update on the number of folks and the number of participants. So we've got 101 folks on board right now.
Wow.
Rati, this is great. Brenda,
should I go ahead and get, or we'll go to?
Yes, go ahead, Brenda.
Okay, welcome to the 27th Annual Santa Clara County Domestic Violence Conference, brought to you by the Office of Gender-Based Violence Prevention in partnership with the Domestic Violence Council. My name is Brenda Farrell, and I am a member of the DV Conference Planning Committee. Today's webinar is California Law and Trauma Informed Court Responses. By the end of the session today, you'll be able to identify key domestic violence cases and what they tell us about the law's approach to understanding domestic violence and the behavior of survivors and their children. We're also going to receive an overview of recent social science studies that confirm the basis for our updated custody and visitation laws, while recognizing the obstacles that survivors and their children face in the court system. Lastly, we're going to identify trauma-informed court practices that bridge the gap between the law, social science, and the experiences of survivors and their children in the court system. We do welcome your questions. Please type your questions in the Q&A feature on your screen, and we'll be able to answer them as we have natural breaks. Also, please look out for the post-evaluation in your email box on Monday, or also there'll be a QR code that you can scan. We do really appreciate your feedback. The PowerPoints will be available by the end of the day on the website of the Office of Gender-Based Violence Prevention, and a link will be placed in the chat. Now it's my pleasure to welcome Arate. She is the Senior Managing Attorney for the Family Violence Appellate Project. Arate manages the training, technical assistance, and law student programs and represents clients on appeal. She has been an attorney for survivors of domestic violence, sexual assault, and stalking since 2009. Prior to joining the Family Violence Appellate Project, she led the Domestic Violence Family Law Project at the Asian Pacific Islander Legal Outreach. Her work focused on trauma-specific client representation, cultural responsiveness, and language access services for survivors. Arate co-chaired the San Francisco Domestic Violence Consortium for 3 years, and as a member of the San Francisco Police Department Access Working Group, she helped develop protocols and training to improve law enforcement interactions with survivors and to improve protections for survivors who were cross-reported to CPS. Prior to working with the Asian Pacific Islander Legal Outreach, Arate had her own family law practice and volunteered at Bay Area Legal Aid. She is a volunteer with NARICA, which is a domestic violence agency for South Asian survivors. She received her domestic violence counselor certification through Asian Women's Shelter in 2009. And she is a graduate of the University of Minnesota School of Law. And as I said, I'm really welcome to all, and I'm really excited to hear this presentation today. Go ahead. Thank you.
Hi, everyone. Thank you so much, Brenda. I purposely made that biography very long so that I would have to talk less. So using up some more time so I'm not on the spot so much. Thank you so much, Julie and Ryan and Carla and everybody at the Office of Gender-Based Violence and the County of Santa Clara for allowing me to be here, for letting me be a part of this really prestigious sort of conference that's been going on, and all the work that's gone into trying to adapt this to the virtual space. When my colleague Jennifer Wagner had done a training for this conference last year and done it in person, and we had talked about me wanting to do it this year. And so we had all these plans about, okay, and now I'm going to do this group and this and that. And life intervened. But I'm hopeful that if not in the presentation itself, in the materials I end up giving you, that you'll meet some of the goals you had for being here. Without sounding like a public television station, I know you have other choices. And so I appreciate you spending your Friday morning with me and dealing with your Zoom fatigue and meeting fatigue and everything else. So let me get started. I think I am the speaker now, so I think I should be able to share my screen. Oops, that's what I want. Okay, here we go. So as is probably not uncommon, I'm hoping for other people who've done presentations, the objectives that I put in my proposal are probably a bit more ambitious than what I'm going to have here today in the presentation, but I'm hoping you'll bear with me. And as I said, I'm going to be providing a lot of citations and some materials in a handout that will go with the PowerPoint, and hopefully that will address some of the things that we don't quite get to today. So just a quick little bit about Family Violence Appellate Project, or FVAP, I call it. Essentially, we're an organization that provides free appellate representation to low and moderate income survivors of domestic violence in family law and other civil areas. And we also do work in housing and employment appeals. If you're not familiar with the appellate process, essentially, if you go to the trial court, so you go to your family court, your local superior court, and you get an order which either you're not happy with or you don't think follows the law, or the other person in your case decides that they don't like that order, they can challenge it up at a higher level. It's a long process. It's not an easy process. It's a very narrow process, but it is still a process. And the benefit from that process can be that if you end up being successful, and if that case is actually published, that case can actually help other people in similar circumstances, so that what happened to you hopefully will not happen to somebody else. And that's a lot of the motivation behind why FVAP has done what it's done, is that we also hope that in helping an individual client with representation, we might actually also be able to provide assistance for many, many more survivors by being able to have a published case that improves the outcome for them in trial court. We also provide training and technical assistance. As I explained, our mission is to assist and protect survivors of domestic violence, including parents and their children. A large part of what we saw and seen is that California actually has a lot of very well-crafted statutes designed to survivors of domestic violence and children. I have done trainings at other stages and national stages and in other states, and some of them would, they would bend over backwards to have some of the language that we have in our statutes. So great, right? But part of the reason why FVAP was founded is because we had these statutes, and yet the outcomes that were happening in court were not reflecting the statutes either in letter or intent. In spite of the fact that these laws were designed to protect, to create safety, to balance people's rights, to protect the best interest of the children, to help people move forward, they were not leading to those results. And it wasn't necessarily the wording of the law, it was the execution of those laws. And what happened is, because of the way that appellate law works, is even those courts that were sort of doing the right thing, a lot of their decisions weren't able to help anybody else because they were unpublished. So in addition to representing survivors, we also try to look at all the unpublished cases that come out every day, which is the majority of cases, and try to find the ones where the courts are really making a difference in applying the law appropriately for survivors and really recognizing the reality of domestic violence and parenting and the dynamics of trauma, and making sure that those cases get published so that other courts, other survivors, other people across the state can use those as well. We have been around since about 2012. We have taken about 1,000 or so referrals for appeals, and we have published about 42 cases through our publication project. So, okay. So today your learning objectives are a little bit more modest, as I said. So you are going to be able to identify a couple family code sections, and we're just going to talk a little bit about, what specific protections they provide to survivors and children. I'm going to talk about one or two recent cases that recognize these dynamics, and then we're going to talk a little bit about how court systems can help reduce trauma for people who have experienced domestic violence that are consistent with the law. So just to get into a little bit of why I wanted to do something like this, if you happen to be here last year, you would have seen the presentation that my colleague gave, which was about social science and DV statutes, and really trying to show why the key statutes in the family code that talk about custody, visitation, domestic violence are supported by social science. And a lot of that presentation went into really, really specific data that we know about, neurological changes, about behavioral changes, about what we know about exposure, childhood exposure to domestic violence. What we know about the behavior of survivor parents, what we know about the behavior of parents who have been abusive. And when I thought about doing this, I thought, okay, I could do all of that again. But part of what the issue is that we actually know a lot of that. And the other issue too is that it doesn't seem to me that it's always as clear to everyone that the law that we have is actually based on that understanding. And so that in following the science, as people like to say, or following the social science, you are actually following the law, and vice versa. So they're not inconsistent with one another, which is, I think, sometimes the way that things are presented, right? Like you're either the court, or you're the lawyer, or you're the judge, or you're the mediator or the evaluator, and you have these very, very different purviews, and you try to mix them together when needed for the purposes of court, and it's not an ideal situation. The other thing that I wanted to talk about too is the fact that what we find in our work at FVAP at least is over and over and over again behaviors that can be identified clearly as symptoms of trauma, which we are completely willing to recognize in other spaces, whether we talk about ACEs, or we talk about trauma-informed juvenile justice, or we talk about other types of things, but those behaviors are not being recognized in family courts as appropriate behavior, or understandable behavior at least, for somebody who's experienced domestic violence or experienced trauma. Part of my job is reading a lot of transcripts. And of course, transcripts don't tell you everything. They tell you only a small piece. But even from reading transcripts, I can read very specifically, and I can tell where there are situations where someone is not being able to express themselves, and the situation and the dynamics are such that they're being shut down, or they're shut down in response to what's happening around them, and it's being used against them. And that is yet another way in which the realities of the law are not being realized for survivors. So that's a little bit of the connection that I kind of wanted to try to make today, however, inartfully. So let's start and talk a little bit about statutes and cases, right? So in terms of where most of our DV law comes from, it comes from these specific areas. It comes from our family code, our welfare and institution code, our penal code, and from California rules of court. This is by no means the only areas in which the law comes from. Actually, FVAP produced something called the Compendium of Domestic Violence Laws every year, and it's about yay thick. It's about 20 or 30 pages, and it goes across all the different code sections that have provisions that are relevant or specific to domestic violence. So these are just sort of the big ones, right? We're going to be talking today about the family code. The Welfare and Institutions Code is what's primarily used for dependency for juvenile justice, which many of you may know. There are cases that have come out particularly recently. Last year, I think it was a case called In Re CM, and there's been one, I think, this year as well, that really try to say that the two systems are very different, they don't have the same purposes, and you can't apply one to the other. And to a certain extent, that's absolutely true. But one of the things that FVAP has found, and we've done this through the publication of dependency cases, including one we had just this year, is that there is a lot more connection than maybe those particular cases that we're saying there isn't want to acknowledge. And there's also very clear overlap. For example, Welfare and Institutions Code, the cases, there's a case called In Re Bruno M that came out, I think, 2 years ago, which makes it very clear that domestic violence as defined under the family code can be used to issue a protective order for a parent in dependency court. Right? So there is cross-referencing there, just like there's cross-referencing with the penal code. And I'm gonna do a little thing in the next couple of slides, hopefully, to show you a little bit more about that. But that's what we're really talking about. I will have some cites to the California Rules of Court at the end, because that's where a lot of the requirements come from for custody evaluations, mediators, minors counsel, that type of thing. But we're not gonna go into that in too much detail. Okay, so that's where it comes from. How do we know what it means, right? Well, if I really had the complete answer to this, I probably would be on the Supreme Court right now, but I'm not, really, and will never be. And this is an argument that we could have days and days and days of training on. So to keep it simple and to sort of just deal with like a basic way of looking at it is that we look at plain language, plain meaning of the statute. Then we look at legislative intent, and we also look at cases interpreting the statute, right? And depending on where the case is from or where the case comes out of, it has more or less value to you. Appellate cases generally have a lot of persuasive value, even if it comes out of a different district than your county or your area of the state. So that's why it's particularly helpful if we can get a case, even if it's happening in an area that's not the same as the one that your client might be in. So for example, we get a case that comes out of the 2nd district, which is generally the Los Angeles area. That's still going to be something that can be useful here in the 6th district, which is Santa Clara. The other thing that I should also quickly say too is that what I'm about today is not specific to Santa Clara County or Santa Clara County courts or Santa Clara County judges or mediators or anything like that. Santa Clara obviously has been a leader in trying innovative programs, having pilot programs, trying different things. And of course, on the area of ACEs and all of these different things, they've really been a leader. Having this conference, is reflective of that as well. But I think we can all learn, we can all do better. And the reality is that, none of us is in a bubble. We have survivors that come from all over the state. We have survivors that come into our counties because they cannot find shelter in the counties where they live, because economically it might make more sense, because they're fleeing. The other person might have moved to a different county and they're forced to litigate their case there. So it is important that as great as we can make our own courts, that we are invested in making all courts at a really high level. Okay, so little did you know there was going to be homework, sort of. So today, these are going to be your words of the day, right? We just talked about plain language. So your words for today, which are both legal words and English words, which is always nice because that's not always true, are shall, must, and, as defined by or in, and as provided by or in. And if you're into bingo, I would absolutely suggest you take out a piece of paper and keep track of how many times you see these words today. Yeah. Okay. So Family Code Section 3011. This is the section that talks about how do you determine the best interest of the child, essentially. All right, so what I wanted to do, just to get us started and just to give you an idea of what what we're dealing with here, if this is not something that you normally work with, is how it's laid out, right? So you'll see here in making, I'm sorry, I gotta move this a little bit here because it's blocking my view of my slide. All right, let's try that here. In making a determination of the best interest of the child, in a proceeding described in section 321, the court shall, among other factors it finds relevant and consistent with section 3020, consider all of the following. That, you know, no problem, right? And then health, safety, and welfare of the child. Okay. The next one is history of abuse by one parent or any other parent seeking custody of any of the following. Right. One thing I want to be clear about here is that it says the court shall consider all. It doesn't say the health, safety, or welfare of the child or a history of abuse, or the health, safety, welfare of the child, and once that's okay, it doesn't have to consider anything else. Sometimes I hear people in our work talk about the best interests of the child, which is generally defined in part as the health, safety, and welfare of the child, as if it's a very obvious binary thing. Even though we all know that there are lots of individual calculations that go into the process, you will hear people say, well, you know, that's because that's in the best interest of the child. Well, I'm really glad that you're very certain about that, but I want an explanation. I want to know why. I want to know how. I want to know what else you considered. And maybe that's the lawyer piece, but I think that's the piece that anybody would want to know in terms of figuring out, should I trust this decision? And we'll talk a little bit about trust in a little bit. So this is the beginning, right? So this is one slide, right? So then you have the next slide, right? So this slide basically goes into the types of people against whom abuse is going to be relevant. So if the person who's seeking custody has committed or has a history of abuse against any of the following people, right? And if you were at any of these trainings last year or kind of follow this stuff, you know that this was all amended in 2018 legislative session to be effective January 1st, 2019. And part of what was included in this is a recognition that abuse against other people, even if it's not the other parent, is important. And this comes from a lot of what, especially if you're working with survivors on a regular basis, you hear, which is that, well, I know that their previous partner filed a restraining order against, but then they dropped it after they got back together. Or, my kid tells me that, when they're at the other parent's house with their partner, there's a lot of yelling and throwing and stuff going on, right? And that gets back to this idea of whether, somebody who has abuse, how are they managing their relationships and their behavior as a whole? And are they able to manage their relationships without using violence or coercion or control? And if they're not able to do it with the parent of the current child, it doesn't necessarily mean that they can do it with other people. And so it is important to know, if you're thinking about the future relationship, the future custodial relationship of that parent with this child, that these things are considered. You'll see here too, it says, as a prerequisite to considering allegations of abuse, the court may require independent corroboration. So that used to say may require substantial independent corroboration, and that was changed. And this is a really important point here, because again, this reflects the reality of what is domestic violence and what happens to people who've experienced that trauma. You may have heard a lot since Shelter in Place about the fact that domestic violence thrives on isolation. And that's one of the reasons why Shelter in Place has provided a perfect opportunity in some ways for people who want to do that to be able to do that, and to be able to do that behind closed doors. so much of what has happened in the domestic violence movement has in theory been to bring it out of the private space and into the sunlight of public scrutiny. And shelter in place is one of those things that seems to have been able to successfully push it back, as it were. And so you don't always have independent corroboration, right? At least here in this paragraph, they recognize that organizations that provide services, maybe it's going to be victim witness or medical facilities or things like that, can play a role in helping to support that. But at the same time, we know that there isn't always going to be independent corroboration. And maybe even if there is independent corroboration, it's from a long time ago, but that doesn't make what happened to that person any less real, or it doesn't make the reasons that they're seeking protection now any less important. Nor does it make the fact that it happened irrelevant to thinking about what's in the best interests of any child that's being discussed here. Nature and amount of contact with both parents except as provided in 3046. Again, I think that this is another thing that's sort of misinterpreted sometimes, and it's important to understand it in the context. So if you remember at the beginning, we just said they're required to consider all of them, right? So it's not you consider one, and then if that works out, you can skip the other ones, right? So nature and amount of contact with both parents is important, but there are exceptions under section 3046, a lot of which have to do with people fleeing, with people who are, it doesn't apply if it's somebody who's restricted by a protective order. It talks about different efforts and things like that. So there's limits. It's not an unfettered consideration. And it's also supposed to be, to some extent, an objective consideration, right? You're looking at what is the nature and the amount of contact with both parent, right? And considering that as part of the big picture. And that's important, right? You want to know, what relationships children have, what relationships children are developing, what stability they have, what would upset that stability. But that's different than saying that, you need to have frequent and continuing contact, which is a different piece of law, and it has different applications in different settings. Okay, we talked about habitual continual use of alcohol. And again, here's another one where it may first require independent corroboration, right? Again, this is an interesting one, right? Because our understanding of marijuana has been a huge change in this circumstance, because what we might know biologically about what it does and doesn't do, and what we might know about what it does to the brains of young people, or to create addictive habits or anything like that. We also know a lot of the stuff that it doesn't do, the things that it isn't that harmful for, and the ways that it helps people. It used to be sort of an easy red flag for anybody to throw up and say, look, this is happening wrong. And now it's a little more nuanced. Now we really have to think about the dynamics of what's going on. And that's complicated. I think that's brought up another level to some of the considerations that we've had. Okay, so one thing I want to point out here too is that if you'll notice, oh my gosh, it's saying my internet connection is unstable. That's not good. You'll notice that at the top of the slide here, it says 5A, right? So this is a way of letting you know that it's number 5. But I will tell you, when you actually look at the statute, everything is not that lined up, right? So if you go back here, I think, where is it here? Yeah, here. So if you go to this one, it doesn't say 2B in the statute. It just says B. I just put the 2 there because it's impossible to follow if you don't have some sense of like what's before you and what's after you. But this is the way these things are written. So I just want to point that out. When the allegations of a parent have been brought to the attention of the court in a current proceeding, the court makes an order. The court shall state its reasons in writing or on the record. In these circumstances, the court shall ensure that any order regarding custody or visitation is specific as to time, day, place, and manner of transfer of the child as set forth in subdivision C of section 6320. Okay, so that's an important piece there, right? Time, day, place, manner of transfer. Those are all safety considerations. Those are all things that help hopefully reduce conflict. Those are all things that you try to do to protect both a child as well as protect parents, protect the parent that has been abused from risk, right? And that's an important responsibility that the court has. And what you're going to see is that part of what happened in 2019 is that there are things that are repeated over and over again. So this is repeated in Family Code 3031. And other aspects, you know, this portion in 5A is also repeated in Family Code 3044. And part of the idea was to sort of connect things so that people would not be looking at these sections in a vacuum and sort of say, okay, well, this is about the best interest of the child. I don't have to look at this because I don't know if there's DV or, you know, I don't know. So I'm just going to look at this, right? Okay, 5B, there you go. So this paragraph doesn't apply if the parties stipulate in writing or on the record regarding custody or visitation. And keep this in mind when I talk later about 3044, because you know, this has a very different context stipulation in domestic, and it's important to remember. And then of course, this is also something that came, I think this was implemented in 19, notwithstanding subdivision A. You all remember subdivision A, right? That was only 5 slides ago. The court shall not consider the sex, gender identity, gender expression, or sexual orientation of a parent or relative in determining the best interest of the child. Okay, so I think, so we have our first poll. Ryan, I don't know if we can pull this up here. Oh, it just said host cannot vote. That's a shame. Am I supposed to be able to see results, or is it waiting?
Ryan will share the results in just a moment.
Oh, great. Okay, good. So people are voting.
That's correct. Keep voting, folks. We'll give you another 10 seconds or so.
This question really sets you up to figure out if you're learning anything or not. So keep that in mind.
Arati, we have about 50% of the participants that have shared an answer already. Are you ready to share the results?
Sure.
Ryan? There you
go. Great. That's fantastic. I love it. Okay, is everybody else able to see the results?
Yes.
Okay, so the winner is, because this is a trick question, right? No, it's not a trick question. But that's great. I'm so glad that was part of the answer. Okay, so because I know you were memorizing every single word on the previous 6 slides, I'm sure you caught the fact that pretty much every sentence in that law refers to some other code section. And that gets back to our words of the day, as defined by, as provided in, right? So if you actually count up all of those things, you will find that there are 7 references to other laws or statutes in 3011 alone. But because this is kind of a trick question, in total, you actually need to read 8, because you need to read all those separate sections plus 3011 itself. So the answer is 8. So for the 10 of you who got 8, you have my deepest appreciation and admiration. And that's pretty much it. That's pretty much all I can give you out of this. But good job. Good job, everyone. So my point basically in bringing this up is that, the legislature has some great laws, but we don't do ourselves any favors in the way that we set this up, right? If you're telling somebody that they have to think about the health, safety, and welfare of children, as well as any relevant factors, any factors that appear as relevant in Family Code 3020, as well as this, as well as that, and you have to think about this, but that definition, you have to go to this section of the penal code to figure it out. I mean, I understand the need to be able to have some consistency, but it's not a big surprise that no one can give you a straight answer about a lot of this stuff, right? So here was my attempt, and I use the word attempt loosely, to try to put together a visual of what Family Code 3011 might look like, right? And this doesn't even include the stuff about stipulations and things like that. But you have here, shall consider all, right? So the key is that all of these things need to be considered, not just one. And you have health, safety, and welfare, history of abuse, and that the next bubble there provides a list of the different type of people involved, nature and contact, except as in Family Code 3046. So which, you basically have to have like 6 pieces of paper around you all the time in order to really keep cross-referencing back. But in general, Family Code 3046 includes points about, what would be improper considerations of absence and relocation. So for example, if someone fled to go live in a shelter and was not able to take the child, or fled without the child, that's not going to be held against them as being out of contact with the child or not maintaining a relationship with the child. History of abusive use of illegal controlled substances, alcohol, prescription controlled substances. And then here we get this nice catch-all, which is other factors relevant and consistent with Family Code 20. And Family Code 3020, in a nutshell, provides that children have a right to be, among other things, it says that children have a right to be safe, free and safe from abuse, and that child abuse and domestic violence are detrimental health, safety, and welfare, right? So here you have something here which actually directly relates to the top up here to that definition. So it is important to have all of these cross references available or understand them. Okay, so this is just a quick slide that's in here that's basically about ACEs, and hopefully, if not from this particular training, from all of the experience that all of you probably have in your own work, and just from being aware over the last 5-10 years, you're aware of what ACEs are, adverse childhood experiences, and that there was a study done by the Centers for Disease Control and by Kaiser, which studied these 10 categories of adverse life experiences, right? And if you'll notice, so psychological, physical, and sexual abuse are listed as a category, as well as emotional and physical neglect. And then separately, you see here, mother treated violently. Now, let's be really, really clear here, right? Domestic violence happens to everybody and can be perpetrated or can be committed by anybody. It doesn't leave anybody harmless. But the reality is that the numbers support the fact that the majority of people who are impacted by domestic violence are women. And in the situation of parents, the majority of women who are impacted, the majority of parents who are impacted by domestic violence are mothers. So this particular study did focus on that. And, the findings were that it had impact later on health, social malfunction, job performance, life expectancy, all the rest of this, right? And I don't say that to trivialize it, it's horrific. But I think that, we have to go beyond saying saying what these things are, and a lot of places have. I know Santa Clara, I know there's a lot of work in the Bay Area. The far north has a ACEs connection. So there's been a lot of work done specifically in California and of course in county to try to turn these findings into a real understanding of what's the data in our counties and what's the data in our schools and what's happening. I think where this has been particularly valuable has been particularly in areas like juvenile justice, juvenile dependency in schools and things like that. It has been less helpful, I think, in figuring out what to do later on, either with older adults or with situations of existing domestic violence. So what's wonderful about it is that it has a tremendous amount of information and help that it can give us in terms of prevention. It can give us some type of background and understanding perhaps of why someone might have been coping the way that they've been coping for many, many years, including using violence. We do also know more about, and I'm not an ACEs expert, but we do know a lot more about what makes one person who has the same level or have had similar experiences not act in a certain way versus somebody else. There's lots of information about having a strong adult figure and resilience and what your community is like and how that helps or hinders you. But all of this goes to say is that it shouldn't be a debate, if there has been, it shouldn't be a debate that these things have an adverse impact on children. And it shouldn't be a debate that if they're happening with parents, that it's having an adverse experience, an adverse effect on the children of those parents, right? If you, I think it's back in 3011, but definitely in 3020, what you'll find is it very specifically says that exposure to domestic violence in a place where children reside is detrimental to their health, safety, and welfare. It doesn't say when they're in the room. It doesn't say when they're old enough to say that they know it's happening. It says where they reside. Now, the point of that is to understand, but the point of that is also not to necessarily punish, right? We do know that parents who experience abuse do lots of things to try to protect children from what's happening in the home, but there are limits. And part of the importance of understanding this type of study and understanding what we now know about, what children, what infants, even before they're verbal, can absorb, or what children can sense, even if they haven't seen it, whether it's the stress of a parent or a mark on the wall or something like that, is to recognize that we can't brush it off. We can't minimize it. We also can't assume that we know how it's affected a child, or that, if we've been through it and we're okay, or somehow that, yeah, this happened, but this person seems all right, that, we have to really be careful of how we rationalize some of this when we're thinking about custody and visitation. I also want to say a quick thing too, just in case it's not clear, and I'm sorry, I don't actually know the full composition of everyone who's here, so my apologies if this is all really basic for you, but custody, just like best interest of the child and a lot of other words, is one of those words that gets used to cover a lot of things. And it really is actually much more limited than you might think, right? You have legal custody, which is about decision-making, right? Decision-making is not visitation. Decision-making is not spending time with the child. Decision-making is decision-making. And it has its role, it has its place. There are important factors about having a parent who does make decisions in your life, and which parents make those decisions or which adults make those decisions. But decision-making is not the same as parental rights in the same way. Dependency is about termination of parental rights, right? You're not getting your parental rights terminated in family court. What you're talking about is you're talking about allocating decision making and who is in the best position to make those decisions and who's going to who's going to cooperate in making those decisions. Those are all important factors. And so wanting to have custody or wanting to have, soul of anything by itself may not actually mean what people think it means, right? For some people, that actually means control. For other people, that means protection. For some people, they think that that means that they're, going to be able to be just sort of left alone. And none of those things are true. And it's really, really important that we not assume that people know what that means, and that we don't judge them simply because they're asking for it as if we know that they know what it means, right? For lack of a more eloquent way to say that. Okay, and so these are just some protective factors that we know about. I think that I don't want to get into the whole debate about what makes somebody, a protective parent versus, other things. There's if you're interested, there is, and I will actually send you some articles. I have a few of them. There are some articles that came out through Family Court Review, which is through the Association of Family and Conciliation Courts, which kind of discusses a lot of the back and forth between, what is alienation or not, what is gatekeeping, what is not, what is protective parenting, what is not. And so I'm not here to kind of get into all of that. But I do think that, we do recognize that there are protective behaviors and that there are behaviors that are protective and that are not gatekeeping, and vice versa. And that they can make a positive influence in a child's life. Just the way that we know that children who have similar ACEs scores or who might have ACEs scores for similar reasons can end up in different ways. A lot of that can have to do with having a positive adult figure in their life, having one stable relationship with an adult, having one figure in their life that they can count on and who will support them in achieving that resiliency. Okay. Okay, I'm going to just talk quickly about this, and then I can take some questions if people are interested in before we move to the next piece. So this is a case that just came out. One of the interesting things that happened after I submitted the proposal for this, but it's something that we knew that was on the horizon, is some of you may know that the Domestic Violence Prevention Act has been amended, and starting next year, there is a specific provision which discusses coercive control. And this is one of those situations where I think really illustrates why FVAP was created and why you see so much work happening by so many agencies on behalf of survivors that express basically frustration with the legal system. Because from my understanding, as long as I've been doing this, coercive control has always been covered in the Domestic Violence Prevention Act. The problem is that it wasn't being applied to those behaviors. And finally, enough survivors, enough legislatures, enough people who had been experiencing this in the court, because especially most people who are in the family courts are not represented by attorneys, got fed up. And even though there is a lot that can be done to make sure that the law is interpreted properly, it got to the point where it was like, well, we need to explicitly state this because they're not recognizing it. And it just so happened that as this was happening, this case came out. And this case is a perfect example, I think, of why coercive control has always been in the Domestic Violence Prevention Act, why coercive control has always been understood to be a type of, I don't want to say a type of violence because it's not, but coercive control has been an element of abuse, right? And an identifier of abuse. And so here, this was a case where basically what happened is that, now I will say in this particular case, the person against whom the restraining order was issued had appealed. And if you know anything about appeals, the deck is really, really stacked against you if you are trying to, if you're trying to challenge a court decision. Pretty much everything is that in a light most favorable to the trial court and to the party that got the favorable ruling. There are some exceptions in some ways in which you can make the appellate court look at everything from scratch. But a lot of things are looked at from this idea of abuse of discretion. And essentially, the abuse of discretion standard, one of the main prongs is no reasonable judge could have ever come to the same conclusion. Well, if you are on the end of a situation where you've experienced coercive control and you've been denied a restraining order, what hope do you have when you go up to a court of appeal if you have to pretty much say that this judge did what no reasonable judge could ever do, right? So that's some of the challenge that we've had with having laws that really do cover things and not having outcomes for people who go to court that reflect that. And that's trauma. That's part of what makes family courts and the family legal system and going through the legal process traumatic and re-traumatizing. So hence kind of why I wanted to do this. So just to briefly talk about this, and I'm going to be sending kind of an alert about this with the materials. Essentially, one of the really important things about this case, aside from the fact that it's recognizing that these acts were not just disturbing the peace, right? Disturbing the peace is a form of prohibited behavior under the Domestic Violence Prevention Act, but so is stalking, threatening, harassing. Sometimes I think people think that you have to make everything disturbing of the peace, and that's the only way, but it's actually not. Disturbing of the peace is one thing, but there are other things there as well. And I'm talking about in the context of non-substantial bodily injury or threat of injury, that type of thing. One of the things that's important about this is that it looks at the constellation of events. And that's a word that I use a lot. I'm sure it's probably been used by lots of other people. So I've probably taken it from someone, so I apologize. But I have always seen, the cases that I've worked with, at least, it's been a constellation of events. It's never just one thing. And it's really, really hard to just sort of pick out the one thing and say that this is reflective of everything. Context does matter. And in this situation, the court was able to look at the big picture. Now you think, oh, that's really great. The court looked at the big picture. But if you actually look at the Domestic Violence Prevention Act, it says the court shall look at the totality of the circumstances. So it's been in the Domestic Violence Prevention Act all this time that courts are supposed to look at everything in context, right? This just happens to be one of the first cases, 2020, that actually makes that clear and talks about it and does it. Not to say that it hasn't happened in other cases or that it doesn't happen at all, but this is the kind of disconnect that we sometimes are having to work with, right? That in order to get this done, even though it's years later, we finally now have this case. We were able to get this case published, though we weren't representing the parties here. And now hopefully it's something that someone else will be able to use in trial court where it hasn't been done before, right? But that's exhausting, right? That's exhausting. It's exhausting for the people in this case who waited years and years and years for this to be resolved. And it's exhausting for people who continue to go to court on a regular basis and are not being offered this kind of overview, right? Who are told that their domestic violence is stale, or that that somehow it happened a long time ago and they should get over it. The other thing that I wanted to point out here quickly, and I just realized I also have no idea how much time has passed. So the other thing that I just wanted to point out quickly is that this is a situation where and first of all, this was a mutual restraining order case. That's one thing that I think is important, right? So in this case, the court actually issued one restraining order and denied the other. And the restraining order it issued protected the daughter, their minor daughter in common, right? Which is another whole, can of worms that we can get into some other time about why courts find DV and then decide not to, or to put a minor child on the restraining order. But in this case, the court did. But the domestic violence they were talking about was a lot of what happened to the parent. The other thing is that you'll see here in the middle that the person who was found to have been abusive said that at one incident, they had texted the photo of someone's nursing license to the other parent, right? And there was nothing with it, right? And the court said, okay, that's not the relevant standard, but look at what we really have here. First of all, if you look at the previous facts, you'll see that McCord was threatening her livelihood, right? But it also goes to show, again, that you cannot look at these things and judge in that moment, well, that doesn't look so bad, or that doesn't, you really have to think about what is the context of all of this. I had a case where someone had a license to operate a business and the person had not wanted them to work. And so the person called up and got that license canceled. But the person that I was working with stayed in that relationship for another 15 years. So yeah, I brought out that evidence and I had to show, yes, that was done. But it doesn't mean that because it was done 15 years ago that it didn't have an effect. There's probably a pretty common story that goes around in domestic violence trainings, I think, that basically talks about, if you're doing something and the other person gets mad at you and makes a fist and hits you, they don't need to hit you over and over again for you to understand that you could get hit. All they have to do is see you make your fist, or sometimes just know that you're there, right? It sends the message, and the message can last, even if it's not repeating over and over again. Okay, so it's 12:28. I'm not sure how much time we have, and can someone help me out? I'm sorry, I think I've been talking way too much.
Dorothy, it's hard to stay,
Yeah, do we have any questions that
We've got
I think
questions.
We should take? Okay.
Yeah, we've got questions and we have about half an hour left. We're going to go until 1, okay?
Okay.
So I'm going to start with a question regarding coercive control. Great that coercive control is being considered in family court. Is there a movement underway to consider it in criminal court as well?
It's so interesting. That's a great question. Thank you for asking that. So let me just tell you a little history. So this bill that is now being made into law was originally written for the criminal code. That's how it started. And to be honest, there were concerns, including concerns from the domestic violence community, that creating another criminal penalty was really not the way to go, and that's not the climate that we're in, where we want to put more people into the criminal justice system. And that isn't also the remedy that survivors are always choosing. And it's a much higher standard, beyond a reasonable doubt. It requires them to be involved with law enforcement, and that putting it in the family code was actually going to be more accessible for survivors of domestic violence who are experiencing these things. That being said, that's not something that everybody's doing. It's absolutely become part of the criminal code in England, Scotland, and other places. I think it's, even people like Evan Stark, who are the sort of the founding father of understanding coercive control, agree that there are limitations, problems, tweaks that need to happen. So it's definitely possible. I don't see it as something that couldn't happen if that's what people want. I think we have to think about that. And I think in terms of the context of, what options survivors have. And I think the other thing to think about too is that violation of a restraining order is a crime. And so there is a potential criminal element in a way with having a restraining order. They're not always prosecuted, they're not always enforced, people don't always call the police. But in theory, if you do have a restraining order and even a temporary restraining order and someone engages in that kind of behavior, you know, there's an argument that they violated the restraining order perhaps, and then that should be something actionable by the criminal court. I hope that answers your question.
Thank you. We've got two more questions. Does the court consider a criminal record relating to other violent acts when considering custody and visitation in a DV case?
Sorry, can you say that? I missed the beginning part.
Yes. Does the court consider a criminal record related to other violent acts when considering custody and visitation in a DV case?
Yes, yes, they are supposed to. And actually, so there's a couple of pieces. First of all, courts are required to check if there's any other type of restraining order in place or any other type of, you know, restrictive order. Second of all, there are actually certain offenses, and I don't have the site handy, but I can put it in the materials if this is helpful. There are certain offenses that automatically can be considered by a court if when thinking about custody and visitation. Not every, but there are certain offenses that are. I think, you know, I think this gets a little bit to the idea too of sort of what's mandatory and what is part of the thought process. Because when you talk about history of abuse, what do you mean? You know, do you mean history of abuse only if it's abuse is defined in the Domestic Violence Prevention Act? Do you talk about history of abuse as what you see as abusive behavior? Do you talk about, you know, all violence? It's a little bit tricky, I think. It's supposed to be, you know, relatively clear, right? You understand abuse as it's defined under the Domestic Violence Prevention Act, and if you see acts like that, that should count. But in terms of mandatory consideration, there is only there are some particular types of crimes that the court is allowed to consider, but there's others that they're not allowed to consider. And you know, the thing that I always think about with these things is that you also have to think about, at least from my experience, is I definitely represented survivors who had restraining orders filed against them as a preemptive strike, as retaliation. Who were arrested in mandatory arrest cities because they couldn't explain, you know, defensive scratches and things like that, and they weren't the first one to call the police. So I think we also always want to balance when we're thinking about, you know, tightening the rules or maybe kind of, you know, coming down hard, what the trade-offs might be if the survivor is on the other side of that. Because I think what, you know, some people will say is that some of these things have actually led to more survivors being arrested, more survivors being prosecuted, more, you know, survivors sort of getting in trouble, rather than really recognizing the actual behavior of people who are being abusive.
One more question. Bringing a case to appellate court can take a really long time. So in the meantime, what can victims do?
You know, this is I will be totally honest, and this is not an FVAP sanctioned response. So I was a trial court attorney for many, many years, and I thought appeals were a waste of time. I will say that completely frankly, because it just felt so out of reach. And it felt like it took so much time, and it just made me think, you know, I need to focus on my client now. I need to focus on what I can do now. I have to go back to the same court, to the same judge. You know, I don't have time to figure out what's going to happen, you know. But at the same time, now in looking back, I would have loved to have some of these cases that we have now in my toolbox at the time that I was originally trying to do these things. So it's a little bit of a give and take. I think that's probably one of the biggest issues, is that there's no quick fix for that. If it's a person who was denied a restraining order, it's a really precarious situation because of the fact that they are not protected. Sometimes what we found is that additional acts of abuse end up happening afterwards, and then there is a basis for refiling or filing a new restraining order. It is true that when you are appealing anything that's a restraining order, domestic violence restraining order, you do have something called calendar preference, which may not sound like a lot, but it also means that you get priority in scheduling. So it is possible to sort of have a little bit of a faster process, but I'm not gonna pretend that it's some kind of quick fix. It's really it's a long-term thing. Having said that, I will also say too that for the cases, for example, where we were able to get denials of restraining orders overturned and those situations went back to court, the message that we get from the clients is that, thank you so much, and I feel very empowered for now having this option, and I have this choice, and now I know I'm going to be heard, and so people have found some value in that, even if it doesn't feel like anything really practical in the short term.
Related to
Sorry,
that,
that's a not a very explicit answer, but.
Aren't they related to that comment? How much time does a victim have to appeal the judge's decision if after hearing if her RO was denied?
That's a great question. It's I'm going to give you this is your new also legal English word for today. It depends. And I say that not meaning to be facetious. It's just that seems to be the way things always are in my profession, is it depends. In general, what we tell people is that it's the earlier of two dates. One is 60 days from the date in which you were served an order or given the order. So for example, in a lot of cases where someone is denied a restraining order, there's no piece of paper that says it, right? But in some cases, they give you a piece of paper that says, your restraining order was denied, and there's other orders on it as well. If they don't give you a piece of paper, if you're not served an order, it's generally 108, which is a long time. And you can imagine maybe with COVID, all of those dates were kind of shoveled around and extended and things like that. So in general, it's 180 days if you haven't been given something. But there's a lot of problems with this, in part because in family law in particular, there's a real problem with people being able to get orders. The courts don't have an order ready. It's dependent on the other attorney. They put it on one person who doesn't have an attorney. And so how are you supposed to know when you've actually gotten an order, what the date of that order is when you've been served? That is an open question a lot of times. Sometimes we see orders that are dated for the next hearing, even though it's from the previous hearing. So we have a tip sheet at FVAP that's called How to Calculate Your Deadline for Appeal that sort of walks you through the steps. So I can put a link to that in the materials or put that in the materials. So if you want to take a look at that, if you have a specific situation.
Arthi, we've got a few more questions and only about 20 minutes left. Would you like to finish your presentation and then get back to questions? Another option.
And what I want to offer to do too is that, and I don't know if this is possible, but what I've done in the past is that, if it's possible to download the Q&A or download the chat, I'm happy to respond individually afterwards as well to any questions that we don't get to.
Thank you. That'll be fine.
Okay, so 3044. So now we're going to do this poll. All right. So I think it's worth doing this poll after having this discussion. So Ryan, if this is okay. I'm just glad my mother isn't here to answer the question because I know which one she'd pick. Aha, great. I want to know if the people who picked the Law and Order understand that it's like 20 seasons of TV. So yeah, so great, right? Like generally, you know, the first one is I'll do it if I get to it, kind of, right? That's what you say, right? I'll do it once I'm done with this, but you never really have any intention of doing it, or you might do it if it comes around. The second one is really, I'll do it as long as it's not in any way inconvenient for me, right? As long as there's not anything, any little thing that makes it slightly unpleasant, uncomfortable, or something like that, right? And the last one is, I'll do it. And I don't have to like it. And it may not be the most fun thing I have to do. And, you know, I maybe it's still, but I'm going to do it, right? I think that's what most of us understand the word shall to mean, right? So keep that in mind. So Family Code section 3044 is the presumption, the rebuttable presumption against awarding custody to someone who has had a finding of domestic violence made against them because they perpetrated domestic violence in the last 5 years. And it's important to say all of those pieces of it, right? It's really easy to shorthand some of this stuff, and it makes it very difficult to be clear about it, right? And I will say that I feel like attorneys are incredibly guilty of this. You know, oh, if you get a restraining order, they won't get custody. Don't worry about it. You know, or, oh, you better not let them get a restraining order because that's it. You know, you're just not going to get any custody. And aside from the fact that that is such a kind of a limited way of looking at it, it's also actually not true. Even as of this year, there's social science data that, you know, Joan Meyer has put out that shows, again, that even in situations where there's domestic violence allegations, a lot of times, either the person who's been found to have committed domestic violence or accused of domestic violence is either getting joint custody or in some cases sole custody. And that was happening when FVAP first started. So, you know, there's sort of the mythology of what happens, and then there's the reality of what's happening in survivors' lives. And if you work with survivors, you know, every day they're not waltzing in there with, you know, their allegations of DV and coming out with like, you know, oh, I'm a winner. It doesn't work like that. Okay, so this is a simple if then, right? If the court finds, then. Now, what's a little bit problematic that says if the court finds is that there are some things that are automatically a finding, even if the court itself doesn't do it. So what would an example of that might be? An example would be a restraining order that was found in another state, for example, or a finding of domestic violence that's been made in any other court about domestic violence that's happened in the last 5 years. So it's sort of like saying the court has to find if there's a finding also, but they can also separately find. But part of the reason why this is important is because in understanding domestic violence, restraining orders are not the be all end all of everything, right? I represented so many survivors who didn't want a restraining order, didn't think about a restraining order, didn't really think that that was the way that they wanted to go for lots of reasons, right? But it had nothing to do with the severity, quality, quantity, the effect of DV on their lives or the lives of their children, right? And so while restraining orders can be beneficial and they're absolutely an important tool and they're helpful, there has to be ways that people who've experienced domestic violence can get protection for their kids without having to get a restraining order. And this law, it perfectly allows that to happen. The court can independently make a finding, even if it doesn't have a restraining order. And that means even if it has a restraining order case and it doesn't issue a restraining order, because you can decline to issue a restraining order for other reasons, there can still be abuse for the purposes of this presumption. And those things get really, really lost in the shuffle, I think, sometimes. All right, I'm gonna flip through this a little bit quickly. Okay, so to overcome the presumption, the court shall find that both. All right, so both, I highlighted that, and then you'll see this is our one of our words for today. So if you're playing bingo, and, right? The perpetrator has demonstrated that giving sole or joint custody to them is in the best interest of the child, and the rebuttal factors on balance support section 3020 findings. It's not the best interest, and that's it. And if you think that I'm being sort of over dramatic about this, we just appealed a case where the court did this exact thing, you know, where they just completely ignored it, where there was a restraining order in case, right? And they were like, oh yeah, it's in the best interest of joint custody. Completely ignored this whole section, right? So it's happening. It still happens today. And we just went through that whole thing where we are like, you know, everybody on this call understands what shall means, right? But for a lot of survivors, they're not getting the benefit of the shall or the and, or a lot of the plain language of the law. So, and the rebuttal factors on balance support section 3020 findings. Okay, so, and again, some of these are changes that happened last year because of, again, the situation where you had these rules, but they weren't being followed. So family 3044, this is an important thing. It has to be dealt with first. They have to determine whether it applies before issuing a custody order. They can't ignore it. If they do make any kind of temporary order until they decide if it applies, they have to follow 3011 and 3020, right? Now, if you go back to that chart up there, you can see all the little things. I'm not going to go up there now, but you know, it still has to be consistent with that. You know, it's so if you're seeing a situation where somebody is waiting to determine if 3044 applies and then is just making a blanket order of joint custody, there has to be some reasoning behind that, right? It has to be reasoning that's consistent with 3011 and 3020, which talks about health, safety, and welfare of the child and other things. This is another big thing, right? In any custody or restraining order proceeding in which the party has alleged the other party perpetrated DV, the court shall, there's that word again, inform the parties of the existence of this section and give them a copy prior to custody mediation. Again, shall. Again, it happens over and over again where this is not happening, right? And it's supposed to happen prior to custody mediation, and it's supposed to be the court that gives it to them, not the mediator, the court. Now you could say, well, isn't the court the mediator? Honestly, the whole reason, if you look at the legislative history of some of this, the whole reason they decided it this way is because they thought that there was too much pressure against survivors in the mediation context. And so when you go back to what I was talking about how that section 3011 doesn't apply when there's stipulation, well, custody mediation is really about seeing if people can come to a stipulation, right? So you really have to balance all those things and think about how are we both, you know, supporting survivors while at the same time, you know, acknowledging, of course, obviously that people do have the capacity to come to agree, and that, you know, it does save the court time and resources. All right, I'm gonna zip through a bunch of things here. So the point of this really is that, you know, a lot of these things came about because of this case called Jaime G, which was litigated at the appellate level by the Los Angeles Center for Law and Justice, a fantastic attorney, Sarah Reisman. And again, here, the court was basically like, it's a shell. Even if you have to stop court and stay in the room and tell the court reporter what the factors are, you have to do it. this is just some stuff about presumptions, right? But again, even the legislature is recognizing this as recently as 2018, 2019. It has been too easy for courts to ignore evidence of domestic abuse or assume that it will not happen again. These presumptions function to counteract the proven tendency of some courts to make judgments based on ignorance or stereotypes. Now, if you've been working with survivors on a regular basis, whether you're an advocate or, a legal aid attorney or kind of stuff, this is like, duh, this is what we've been trying to tell you, right? But it's great. It's great that the legislature recognizes this. And again, this is not all courts. This is not all judges. And this is not like, there are a lot of really well-intentioned judges. There are a lot of judges who are not only well-intentioned, but do the right thing at the right time in the right place. But it's not enough. And it's not enough across the state to be, not having a negative impact on survivors. Okay, so we went through these required factors. One thing that I wanted to point out that I thought was good is in this Jaime G case, this is something that I thought was really important. If you're someone who's worked with survivors in trying to get a restraining order, or if you've been an attorney, you know how difficult it is to get a court to order a batter's intervention program in a domestic restraining order. It's there, but there's a lot of reluctance, whether it's because the length of time. I know Santa Clara has a pilot program where it's shorter, I think, or the cost or whatever it is, right? But most of the time, courts don't order it, and they don't even give an explanation as to why they're not going to order it, right? And it's sometimes because I think they don't actually have one. And one of the things about this case that I thought was great is that they specifically say, the court started to state its findings, but it didn't complete that statement. And the omissions that remain raised questions. For example, the trial court awarded custody to a father whom the court found was a batterer. The court, however, imposed no batterer's treatment program on father. Why? We don't know. Sound logic may support a deliberate and thoughtful choice on this score, or the court simply may have overlooked the statutory suggestion of such a program. I mean, that's pretty amazing when you think about it, right? You have an appellate court basically saying that they think the trial court could have possibly just not, just like left it out, just forgot, something like that. But that's a very euphemistic way of what I think we all see in a lot of cases, which is that they're not being held accountable, right? There's not that accountability for, okay, we asked you for a batterer's intervention program because, legitimately we want this person that we love and may still love to get help. And you just ignored it, or you just denied it for no reason. Why? Why don't you have to say why? No? All right, we're gonna spend the last couple of minutes talking about trauma and behavior in the courts. And this is, of course, what I really wanted to talk about. And we're not gonna have time. All right, so I'm not gonna go into all of this stuff. So I did wanna talk about trauma specific. And the reason I bring that up, and just to say, I know that Santa Clara County has a lot of tremendous resources. For some reason, this website, which I know it's part of a big Bay Area collective, they had it sort of laid out exactly how I needed it. So that's why I grabbed that instead. But I wanted to talk about trauma specific, right? Because trauma specific treatment is used generally in the context of behavioral health. But I really think it's something that we need to be talking about in the context of legal help and in legal systems, right? Trauma specific treatment a lot of times can be a specific program, a specific path that someone goes on. But the idea is that it's tailored and that it's supposed to help with some kind of recovery. In the DV counselor, sort of DV legal aid world, we talk about client empowerment, right? We talk about how do we not just represent a client or advocate for that client, but find a way to make sure that the way in which we're doing that gives agency, helps regain agency, keeps the agency that the other person has, and that they come out of the experience feeling stronger and better for themselves. And the fact of the matter is that no matter how good any, DV advocate or attorney has gotten at that, the courts have the capacity to stomp on that in a heartbeat. And that's why we really need to start thinking about it in the context of the court too. It's not just about changing the lighting and the dynamics and maybe changing the name of a certain department. You really have to start thinking about, what it is about the specific people that are appearing in front of you and what do they need while they're in front of you. I think the conversation really needs to move even further than it's been to that. Re-traumatization. Okay, this is a little bit of this. So just to get to, sort of the situation is, so over 90% of domestic violence litigants are self-represented. DV victims often represent themselves. Courts are supposed to take an active role in developing the facts. That's not a clear role right now. We've had cases where the active role in developing the facts has been berating the survivor for all the choices they made. So I don't think that was the intent, but that's sometimes what happens. And this is an interesting piece here when you think about appeals, because in such a hearing, the judge cannot rely on the self-represented, or I prefer to call them unrepresented litigant, to know each of the procedural steps, raise objections, ask all the relevant questions, etc. But on the other hand, we also have a rule that says that people who do not have a lawyer in court are held as responsible for knowing the rules and the procedures and what they have to do as an attorney. Completely seem to, negate each other out. And if you don't preserve all your rights, one of the things that FVAP does is talk to attorneys about how do you make sure you preserve all of your rights. If you need to appeal, you can give up your right to appeal on certain issues. So if the judge does something wrong and you don't say anything about it in that moment, in some cases that can prevent you from saying anything about it in appeal, completely, disregarding the huge power dynamic that exists there, as well as the fact that someone might be unrepresented. Now, to their credit, there are definitely appellate courts who have understood that and who have not, who have sort of moved past that and said, well, normally in this situation, this would be waived, but we understand in this situation, it couldn't happen. But in general, the way the law is written, the way the rules are written, that person is out of luck. All right. So I want to talk about this hopefully as quickly as I can. Cultivating mistrust. So we talk about trauma, right? And we talk about the different kinds of behaviors that people who are in trauma may express. And there's a lot of discussion about, how do we have a meeting with someone who we know is in trauma? How do we create an environment where someone, is that's trauma informed? And yet, even when we're thinking about that, things happen in this person's life that chip away at our efforts to show a trauma-informed process. And let's talk about what happens in court, right? If you are someone who works in the court and you are dealing with a tremendous amount of stuff and a tremendous amount of stress and everything else, the one thing I guess I would ask you to do is try to think about, or maybe ask a friend or something like that who isn't otherwise involved, to just show up one day. And obviously with COVID, you can't do it quite that way, but it's still pretty difficult, as a public member, and have them tell you what they observe. Because I can tell you that from working with clients that people who come to court see everything, they observe everything, and they process everything, and it affects their ability to protect themselves from being re-traumatized, from being able to present their case, from being able to communicate in so many ways. And a lot of it may not even be directed at them, but because it's happening in front of them, because it's happening in that environment, it's still affecting them. And one of the things I specifically want to point out, I've got a couple of examples here, but you go to court and you'll hear the judge say, well, that didn't show very good judgment, did it? Or that wasn't very smart, or how did that work out for you, right? Or maybe you hear a judge saying, you know what, I don't want to hear it. I don't have time. this is just a he said, she said, that's one of my pet peeves, that statement, because to me, it's completely minimizing what somebody is saying. Basically, what you're saying is that your voice has no independent value compared to this other person's voice. And minimizing a person's experience or somehow holding them to a really high standard. So you'll see these things at court where they'll say, to get a domestic violence restraining order, a person merely needs to show that it was more likely than not that this happened, right? And there's a tone sometimes that comes across, which basically makes it seem like they really don't have to prove much, but they're going to get one anyway, right? And at the same time, it's the same standard that someone needs to show to rebut the presumption on custody, right? We make it seem like the presumption against custody is this huge mountain that's impossible for people to climb over. And, we've made it too difficult and it's too severe. It's the exact same standard that somebody needs to get a domestic violence restraining order. So why is it so much harder in that context and not, and nothing in this context, right? Another thing that you'll see a lot of times is they'll say, you know what, you need to know that getting a domestic violence restraining order against somebody can cause severe consequences to their life. It can cause them to lose their job, their housing, their immigration status, their this, their that. I've been in a courtroom where not my client, but somebody else who was there for a restraining order left in tears after hearing that, right? What are you saying when you do those kinds of things? And are you taking accountability for that? And that's not a resource question. That's not we have too many litigants, or we don't have enough money, or there's not enough personnel. That's just, what are you saying? What are you communicating? And just at the end here, there's just a couple slides here that talk about, what people in court see and how it can affect them. One thing that I wanted to say too is that we talk about in terms of trauma-informed systems, or in ACEs, for example, we don't say, what's wrong with you? We say, what happened to you? So maybe we need to stop saying, why didn't you? Why didn't you call the police? Why didn't you leave? Why didn't you tell them not to do this? Shouldn't you have done this? Didn't you think to do this? And maybe we need to start asking, what did you want to do? What did you think might happen? What got in the way of you being able to do that? Right? And understand that we actually might honor a person's experience and understand more about what they did, rather than sort of cynically assuming that because they didn't do or didn't behave the way we said they're supposed to, that somehow they weren't experiencing this. Two things that I want to point out and that I will also put in the resources. So I want to give a mention specifically to Judge Lynn Tepler, who is a judge out of Florida, who's worked with the National National Juvenile and Family Court Justices Association, NJCFCJ, and has been one of the people who's done a lot of work on trauma-informed courts. She has done it on work mainly with juvenile courts and with some other things, but she's done it in the context of domestic violence as well. I will put a link to her presentation and her materials, and I really encourage you to take a look at it. And it gives you an idea, much more specifically than I am, about the ways in which trauma behavior is being misinterpreted by courts and being used to prevent them from accessing justice. The other thing that I want to say is that there is a report that came out last year, which there's a judge from Santa Clara, Judge Yu, maybe, I think, was on. It's called the Bench Guide for Handbook for Self-Represented Litigants. And if you're somebody who works with people who don't normally have an attorney and you read the first 4 pages of this, it's exactly what we have been talking about for so many years about, what do clients notice? How do they feel? What does it mean to not have a voice? Why is it that they don't have an attorney? It's not because of their choice most of the time. What are they getting from the way that you send messages from the bench and things like that? So I really encourage you to read that and encourage you to think how you might use that in helping to support your clients if that's what you do, or to think about how your system is running if you are in the court system. So thank you so much. I know we went 5 minutes over. I really appreciate your extra time hanging in there. Yeah.
Thank you. Thank you, Arthi. Yeah, I'll share with you one comment from our participant that said, thank you for this wonderful presentation and bringing forth the manner in which the court can re-traumatize and be condescending to survivors, sometimes unknowingly. So thank you for sharing your knowledge with us. Participants, if you're still on, I want to remind you that Arthi will provide responses to your questions and will attach them to the conference materials on the web page where you registered. I've shared the link in the chat. You'll be getting a follow-up email with the same information. Please check back to the website regularly. Thank you all.
Sorry, just one quick thing. I'm going to put my email there. So if you have something that you don't feel like you want to, or if it's anything specific about a specific situation, feel free to just email me directly, because I know that sometimes happens. Thank you all so much for your time, and I hope you at least got lunch or will get lunch now, and have a wonderful Friday and a great rest of the weekend.
All right, it looks like we've got 17 questions actually. So what I'll do is download them and I'll send it to you on a Word document, and then you're muted.
Sorry, yeah, I'm just reading them now, so yeah.
Oh, good, you're seeing them. Okay,
yeah.
Well, wonderful. I'm glad you can see them. And then if you want to send your PowerPoint first, I can get that up right away, and we can supplement it when you have the responses to the questions that are appropriate to answer for a general, for general consumption.
Okay. So, sorry, did you say you were going to put it, or should I put it in a Word document, or how do we?
We can download them on this end and email them to you.
That'd be great. Yeah, if you can do that, that would be great. And like I think I made a lot of promises about other things I was going to add to the handout, so I'll need a little bit more time.
Yeah, of course. Very, very well understood. Not a problem. We can share the resources as soon as you're ready and feel comfortable with all the content.
Okay. Do you think it went okay?
I think it went fine. I think it's such a difficult circumstance, presenting when you're just staring at yourself on the screen, and you keep it lively and upbeat, and you've got your slides with a lot of the facts there for folks to reference and read along with listening to you. So you did a great job.
Oh, you're very kind. Thank you. I hope next year it'll be in person and that I can come back, because I really I love these I love the subject and the way it's framed for this conference.
Okay.
I can bring a better self to it when I'm not sitting at a table. But thank you. I appreciate the feedback.
You did super. We'll be sharing the evaluation results with you as well once we get those tabulated.
Fantastic. That's great.
Okay. Are you comfortable with us ending the webinar now, or would you like to still preview those questions before?
No. I'm comfortable now. I'm totally fine. Yeah. I'm sure you need a break too. Thank you so much. Thanks for the polls. And I know that was really last minute, so I appreciate it.
Yes, all good. Take care. Thanks a bunch.
Take care. Bye.
Julie, how do you save the questions?
Yeah, I think Carla went in and did that already. So she logged on and she downloaded them already. Let me make sure she only got 14. Seems like we may need to get to the report. I'm going to stop the recording first.